Hello, everyone. My name is Ariella Wagner. I am the founder of SunRay Construction Solutions, a national construction document service. We help thousands of subcontractors and suppliers secure their lien and bond claim rights through our incredible online system. Today, we have a spectacular webinar given by the incredible Alex Barthet on what happens after I record my lien. How do I get paid? And without further ado, I introduce the great attorney, Alex Barthet.
Thanks, Ariella. Again, my name is Alex Barthet. I am a board certified construction attorney here in Florida. And we get this question a lot. Okay, I recorded my lien. Now, when do I get paid? How do I actually turn this piece of paper into money? We're going to answer that question. And I will explain to you the steps you need to follow so that you can get paid. So let's go over the agenda for today. We're going to talk about what a lien is and how it works and why it is absolutely critical that you record liens. We'll talk about what happens after you record the lien and the steps you need to take in order to get paid. And then I'll talk about some scenarios that you may run into over the course of recording a lien and trying to get paid. Some of them include people saying that they're going to bond off your lien. A contest of lien is a document you may receive. We'll talk about that. A 20-day summons. Again, these are ways that people can contest your lien. We'll talk about that. And as we do on all of these webinars, at the end of the webinar, we will answer all the questions you have. And to submit your questions, use the GoToWebinar question and answer box. We will queue up all the questions and answer them all at the end. Make sure, please, not to include the names of any people or companies in your questions. All right, so let's get started. So what is a lien? A lien is an encumbrance on the real property, meaning it prevents people from selling and refinancing the property because you have made a claim to some interest in it. It is a cloud on the title of the property, just like a mortgage. If a lien does exist on a property, that typically is what's called a technical default under most mortgages. Little tip here, sometimes if you inform the mortgage company that you've recorded the lien, a lien on the property, that can sometimes spur an owner to pay because they may get a letter from their mortgage company saying, hey, there's a lien on the property, you need to take care of it because that constitutes a default on the mortgage. It doesn't always work, but on residential mortgages, we sometimes see it have an effect. So the other thing that a lien does is that depending on where you are in the chain of contracts, that lien is going to prevent the owner from paying the prime contractor. So your lien is like a wrench thrown into the gears of the payment process between an owner and a contractor, and that by itself may get you paid. And if there's a lender involved on a construction project, lenders do not want to fund month to month if there are any liens on the project. There are some ways to get around it, but generally speaking, lenders are not going to want to continue to fund a construction loan. So what happens after you record your lien? The short answer is nothing by itself. I talked about some of the pressure that the lien creates, but aside from that, nothing happens on its own. You record the lien with SunRay, for example. SunRay will record the lien electronically for you, and it just sits there. Nothing happens. The court doesn't automatically kick into gear to start getting you paid. So generally speaking, unless the lien bothers someone enough to pay you, it just sits there. So then the question is, well, if nothing happens by itself, how do I get paid? Well, you have to understand that the lien is the beginning of the process. And to be clear, actually, the notice to owner is the beginning of the process. We've done many other webinars in the past. They're online on the SunRay website. We will do some more later on in the year about notice to owners and the importance of those documents. But once you send the notice and then you record the lien because you haven't been paid, that really is what kicks off this whole process. So it's up to you to enforce your legal rights through an action known as a foreclosure. That is effectively saying to the court with court papers, it means you have to hire a lawyer, that you are claiming an interest in this piece of property and you would like the court to sell the property such that any equity that exists in the property be given to you and anybody else that may have an interest in the property, to take it from the owner, sell it to a third party, and then pay the people that are owed money. That's what the foreclosure process is. It's similar to any other court process as far as time and money. If you wanted a rough estimate, a fully contested foreclosure could take 8 to 18 months, and it could cost tens of thousands of dollars in legal fees before you get to the end. Most every case settles. It usually doesn't take that long, and it usually doesn't cost tens of thousands of dollars, because remember, the lien and the foreclosure process is intended to bring some pressure to bear on the parties that owe you the money to cause them to pay you. So many times we see that the lien by itself gets you paid, and if that doesn't get you paid within several months of after filing the lawsuit, you usually can get paid, unless it's tremendously complicated. There are lots of issues like delays and claims of defective work, but those issues aside, the pressure of the lawsuit usually gets you paid. And unless the time is shortened, and we'll talk about how it can be shortened, you have 1 year from the recording date of the lawsuit, recording date of the lien, to file your lawsuit to foreclose on the lien. That is the outside deadline. I do not recommend taking that long. But if you wanted to wait till the absolute last minute, unless it's shortened, you typically have 1 year from the recording date of the claim of lien to file your lawsuit to foreclose. Now, here's something very important to know. You do not re-record the lien at the expiration of the year. If you do not file a lawsuit within the 1 year to foreclose on your lien is gone forever. It will not come back. You cannot re-record the lien. So you have to make a decision before that time if you're going to go through the process of the foreclosure to keep that lien alive on the property. So one of the things I would recommend is what I would call the 60-60 rule of collections. No later than 60 days from your last date of work. That's when you have to, the last date of work is when the time is measured for you to record your lien. You have up to 90 days. Those are calendar days, counting all weekdays and weekends and legal holidays in between. You have up to 90 days to record the lien. I would say no later than from about day 60 after your last work, that's when you should start the process to record your lien. Do not wait until the 85th day, 70th day, 89th day. We've had clients, come to us the day before the lien is due to be recorded, and that it's a challenge to get it recorded in time. On top of that, because of electronic recording, which, everyone's used to Amazon getting things in, a couple of hours, the clerk does not work that way. Miami-Dade County, for example, is currently on a 5-day backlog, meaning when you submit a document to be recorded electronically in Miami-Dade County currently, that document will not be recorded for 5 days. So that means if you waited until day 87 to submit your lien for recording, it will be late. There is no exception because you submitted it on time versus when the clerk recorded it. So you can absolutely not risk waiting too long to record your lien. So that's why I recommend you start at day 60. Then for the next 60 days after you record your lien, you hassle your customer, the contractor, and the owner for payment. Phone calls, emails, go visit them in their office to go pick up a check. Our most successful clients in collection have an internal, robust collection process, meaning they don't just record the lien and hope that they get paid. They are actively following up with their customer, the owner, and the contractor to get paid. The more work you do, the less likely it is that you're going to have to hire a lawyer to help you. But I would say for the next 30 to 60 days after you record your lien, you are actively trying to get paid. If it doesn't work, meaning 60 days go by and you still haven't been paid after you recorded your lien, that's when I would recommend you hire someone like me to be able to start the collection process for you. You can wait. You may have a business reason to wait. You may decide, you know what, it's a $10,000 lien. I'm doing hundreds of thousands of dollars with the same owner or same contractor. I'm just going to let it sit. I'm not going to worry about it. Those are business decisions on delaying the collection efforts, and you're more than welcome to make those. Aside for a good business reason to wait, we typically find that the liens that we pursue legally sooner or closer to the date it was recorded versus closer to the 1 year when it has to be foreclosed upon, we get better results for our clients when we actively pursue collection of the lien closer in time to when it was recorded. People's recollection is crisper. People are still working for the company versus, a year later, who knows where they went. We've had cases where people have actually passed away because the client waited so long, and it's hard to get testimony from people that are no longer around to support your case. So let's talk about some of the things you may run into after you record the lien. Someone tells you that they will or have bonded off your lien. Now what do you do? In my opinion, you should celebrate. And the reason is that a lien on the property is an encumbrance and requires the property to be sold such that any equity is given to you. Meaning, if you lien for $100,000 on a property that's worth $1 million, but has a $1 million loan or mortgage or construction loan on it, your lien is likely going to be after the construction loan, which means if you foreclose on the property to sell it, there's not going to be any equity. So your lien is not really worth anything. You only get the equity from the property. You don't get the gross proceeds from the sale of the property in the foreclosure. Now, sometimes contractors and owners may decide to bond off your lien so that it doesn't encumber the property anymore. If they do that, they have to get either a surety bond, like from the Hartford, Travelers, CNA, Westchester, Liberty Mutual, or they post cash with the clerk. They take a cashier's check to the clerk's office. Generally speaking, this bond is about 150%. There's a formula in the statute, but in round numbers, it works out to be about 150% of the lien amount. So if you lien for $100,000, they're going to have to post a bond for $150,000. That extra amount is intended to cover interest and legal fees that you may incur in pursuing the bond claim. So if the bond is posted, your lien is no longer on the property, your lien is on the bond. You still have to foreclose on the lien to cash out the bond, but now instead of there being the possibility that there's no equity in the property, you know that there is a pot of cash set aside just for you in case, if you win, that will be liquidated to pay you. The good thing is you're fully secured. The bad thing is you should prepare for a fight. And the reason I say that is because anyone that is going to go through the trouble of bonding off your lien versus picking up the phone and negotiating a resolution means they don't want to pay you. So our advice to our clients is if anyone bonds off your lien, you should immediately cease your collection efforts if you've commenced any and hand the file over to a construction lawyer, because much more likely than not, almost 100%, the person that posted the bond, whether that's the owner or the contractor, does not want to pay you. So you should just put on your gloves and get ready to start the fight to move forward as quickly as possible. In the 20 years I've been practicing construction law, not once have we had a situation where someone bonds off a lien and then negotiates a resolution without us having to file a lawsuit first. So keep that in mind. What are some of the other things you may deal with? You may receive what's called a notice of contest of lien. If you get one, what is it and what do you do? I told you that you have 1 year from the recording date of the claim of lien to file your lawsuit. But if you get a notice of contest of lien in the mail, you need to file your lawsuit immediately. The rule is that this notice of contest, upon it being served by the clerk, not the day you receive it, the day the clerk stamps it as the date he or she mails it, you have 60 days to file your lawsuit on the lien. Not 1 year, 60 days from that date. So if you get a notice of contest of lien, you need to file your lawsuit. Again, this is another indication that someone wants to fight with you because they don't want to pay you, they don't want to negotiate with you, they want your lien extinguished quickly. So our advice is if you get a notice of contest of lien, file the lawsuit immediately. If you don't, on the 60th day, the lien is extinguished. So at the expiration, I should say, of the 60th day, your lien is extinguished. And the case law on this issue is very harsh. There is no time to extend. If you were looking for a lawyer, you were out of town, you were in the hospital, the court doesn't care. You have 60 days. You need to solve this problem before then. Once you file the lawsuit to foreclose on your lien within that 60 days, then now the pressure is off and you will move forward with the foreclosure. So the notice of contest doesn't get rid of the lien, it just forces you to file the lawsuit sooner. Now, sometimes 60 days is too long, so there's a way for owners or contractors to reduce it even more. The 60-day notice that I just talked about is a document that you will receive via certified mail. This next document, which is called a 20-day summons, is different. If you receive it, just like the 60-day notice, you need to file a lawsuit immediately to foreclose on your claim of lien. As I told you, the rule is 1 year to file a lawsuit from the date of recording of your lien. Now, once you are served with this 20-day summons, you have only 20 days to file your lawsuit. The 60-day notice is served by certified mail. The 20-day notice, the 20-day summons is served upon you by either the sheriff or a process server. It is a true legal action. It's going to look like a court filing because, in fact, it is a court filing. If you do not file a lawsuit to foreclose on your lien within those 20 days, your lien is automatically extinguished. So we've covered a lot of material pretty quickly. I've given you a roadmap of what to do to collect the money that's owed to you once you record the lien, and I've explained some of the pitfalls or traps that you may see after you record the lien. So Ariella, if we have any questions, I'd be happy to answer them now. While you're looking for that, if you want some more information on construction law issues, liens, bonds, contracts, You can subscribe to our podcast, the Lien Zone podcast. You can go to the lienzonepodcast.com. And we have a new episode every week. You can get it on iTunes, Google Play, Stitcher, or wherever you listen to your podcasts. Any questions, Ariella?
You know, we do not have any questions, but I think a question that comes up very frequently are attorney's fees. And when do I contact an attorney? And I've only leaned, I know I'm asking multiple questions, but I think there's some important it's the fee. So unfortunately, you have a project and you do all this work and all the profit at the end is in that lien. And then you have to put out more money for, an attorney. So what would you suggest to people, like thresholds for how to move forward with an attorney, and when should you reach out to an attorney?
It's a good question. And when I speak with prospective clients, it is one of their first questions, which is, thank you for explaining the process. Can I recover my legal fees? So the short answer is there are two ways to recover legal fees in the state of Florida. One is if you have a written agreement with the party that you're suing or that is suing you, and that agreement says that the winner gets their legal fees. If that's the case, then at the discretion of the court, at the end of the case, the court will award the winner, as he or she, the judge, determines the winner to be, that portion of the legal fees that they determine is reasonable and related to the written agreement. So that's one way. The other way is, by the way, that's a great reason to have a written agreement versus an oral agreement, and a great reason to have terms and conditions in your agreement, whether it's a proposal or an estimate. So because you want to be able to recover those legal fees. There are lots of other terms, but that's one. The other way to recover your legal fees in the state of Florida is if you sue someone for violating a statute, a rule on the books that says that the winner gets their legal fees when they win. The statutes that are most relevant to construction that provide for the recovery of attorney's fees are two. One, the lien statute. So when you record a lien and you sue to foreclose, and if you prevail, the judge is supposed to award you your legal fees as the winner. If you make a claim on a payment bond because you're owed money, the payment bond statute says the winner gets their legal fees. So if you sue a contractor's payment bond and you win, the court is supposed to award you your reasonable attorney's fees. So those are the ways that you can get it. But I'm here to tell you, again, having done this for more than 20 years, the reality is most every case settles. And as a result, one of the things you have to look at is when you come to, when you are at the point that you need a lawyer to help you, the reality is that you have some amount of money that may be due to you on paper, but you have been unable to turn that into cash. So the reality is that you have nothing, right? You have no ability to recover the money, and now you need the legal system to help you get paid. So most every case settles. So as a result, one of the ways you should look at spending money on legal fees is how much money, or actually how little money, do I have to spend to get the most from the other side in the settlement. So if you're owed $100,000, right, but they haven't been willing to pay you, and you pay $10,000 to get the $100,000, that's a pretty good day. Now, did you get absolutely every penny? No, because you spent $10,000. But remember, when you started the process, they weren't willing to pay you anything. So part of this is how you look at the problem. Most cases settle, and quite frankly, most cases settle if the client has done their homework, properly sent a notice, recorded their lien, documented the project well, complied with the terms of their contract. In our experience, most clients recover most or all of their money, and in some instances, they're able to recover some or most of their legal fees that they incur. And every case is different. And when we talk to clients, we give them a rough estimate of, based on our experience, what we see them needing to spend in the near term to get to the next step in the case, ideally to put enough pressure on the owner or the contractor or their customer to get them paid. So with that, Ariella, if there's still no other questions, let me mention the next webinars that we have. We do these webinars for free every month. The next one is on May 26th, and it is on 3 contract terms that should not be in your next contract. We'll talk about some provisions that we see on a regular basis that you should remove from a contract when it's presented to you, and absolutely make sure that it's not in your contract if you can avoid it. Not always possible, but at least I'll identify those for you so that you know what to look for. And then in June 23rd, from 9 to 9:20, bad checks and credit card chargebacks, how to deal with them. What to do when someone pays you with money that's no good, whether that's a credit card that they charge and then charge back, or someone gives you a bad check. We'll talk about some strategies on how to deal with them. You can sign up for these 2 upcoming webinars and the webinars for the rest of the year, which are all on sunraynotice.com/webinars. Here's our contact information again. Feel free to reach out to me, Alex Barthet, at alex@barthet.com, or Ariella at sunraynotice.com, and we will answer any other questions you have, even if you think of them after this webinar. Did I miss anything, Ariella?
One person, would you just go back to the QR code screen, please? Someone was requesting some information there, so you could go back a few slides. And then the person that asked a sentence, if you could be a little bit more detailed in your question. I'm reading, wondering if I can get the written material to review it later. Oh yeah, okay, I understand now. You would like the PowerPoint, so not a problem. We will be sending out the presentation to everyone on the webinar.
And on top of that, Ariella, right, you post these presentations within a few days, the whole video, again, on your website, correct? On the webinars webpage.
Absolutely. All of the webinars are accessible to everyone.
Perfect. Great. Well, thank you very much, everyone, for participating. If you have other questions, send us an email. Otherwise, have a wonderful day.
Great. Thank you so much, Alex. Have a wonderful day, everyone.